Welcome to Amicus, a law review with Jim Santel, Civic Media's weekly review and discussion of some of the most significant news stories in the areas of law, government, courts, and the aspiration for justice. And now, here's your host, Jim Santel.
This is Amicus, a law review on the broadcast stations of Civic Media. Along with my terrific producer, Greg, I am delighted, I am honored that you have chosen to spend some portion of your weekend here with me, with us, in discussion, in review, in examination, and exploration of some of those major issues in the areas of rule of law and government and the administration of justice. We're beginning here on the broadcast stations of Civic Media, just a bit delayed this weekend because of some gremlins in the system, but they have now left, and we are together here talking about all of those issues and more. Let me give you a bit of a sense of what is ahead in this hour and next hour as well as we explore those various areas. We are necessarily going to be spending the lion's share of our broadcast talking about our Attorney General and that calamitous, that melee of a set of testimonial appearances this past week by the Attorney General before the House Judiciary Committee. We're going to talk about exactly what it is that Pam Bondi, our Attorney General, said to members of the House Judiciary Committee. We'll talk about some of the lessons we should take from that in the areas of rule of law. And yes, indeed, we're going to chat about things like professionalism and competence and humanity and compassion, humor, self-deprecating approaches to life. We're going to talk about personality and engagement, and yes, indeed, core legal skills as well, how one can be effective as an advocate, and how this past week's appearance by the Attorney General before the House Judiciary Committee was a masterclass in not doing any of that. I'm going to provide you with some perspectives of mine based upon my 30 years of employment and work under 9 different attorneys general of both parties. I'm going to talk a little bit about some of the things that we think about when it comes to law schools and the work that I am doing, as many of you are doing as well, engaging with young people. In particular, my work with high school and college mock trial teams and the things that we talk about that apparently our Attorney General of the United States of America does not appreciate and not understand. This was undeniably one of the most significant rule of law events of recent years. This administration obviously has had many of them, virtually all of them, upsetting the basic norms and standards by which our nation has lived and breathed for the past 238 years. Nonetheless, a new low this past week as our Attorney General appears in front of the House Judiciary Committee. One of the other major themes of our discussion today is going to be none of this had to happen. And indeed, she could have performed, could have presented herself, could have presented information and insight in a way that would have garnered applause, if you will. But she chose not to do that and went in the opposite direction. We're going to talk about all that and going to hear some of the exchanges, not all of them from the 5 hours of her testimony, but some of the exchanges between her and members of the House Judiciary Committee. In our second hour, a few more rule of law issues. Again, a busy week in America having to do with this decision by a federal grand jury not to charge those members of Congress, formerly in the military, formerly in national security, with what? Violations of what federal law? For stating what the law is, which is simply that military officers have not only the right but the obligation to decline to follow unconstitutional and illegal orders. For doing that, they've attracted the attention of this administration. They've attracted the attention of America. This past week, a grand jury declining the invitation of the United States Attorney, declining the invitation of the Attorney General to indict them, charge them with crimes for their involvement in that video that you have seen repeatedly in the past weeks and months. And then we're also going to talk about, in that same context, a decision by a federal district court judge blocking the defense secretary, his name is Pete Hegseth, for punishing Senator Kelly for his involvement in that event. Then we're going to go inside the Department of Justice itself, talking a lot about the ways in which these days the Department of Justice having difficulty not only retaining good people, experienced people, the people who know what they're doing, but also showing the door to many people who should remain there, having some significant problems in recruiting new assistant U.S. attorneys, new trial attorneys, and we'll talk about one of the application questions that new applicants for Department of Justice positions now need to respond to as a part of this administration's recruitment of new attorneys. We will also talk a little bit about, in the context of rule of law snapshots, a little bit about Steve Bannon back in the news again, some behavior by our Department of Justice that gives him yet another pass on being exposed to responsibility for the criminal actions in which he has been involved. And we'll talk a little bit more about that Fulton County raid of a number of weeks ago, the revelations that come out of the disclosure of the underlying affidavit that gave a judge arguably probable cause to believe that there was evidence of a crime in those election records, some 700 boxes of polling information, somehow justifying a search of materials that are at least 5 years old, if not more. We're going to talk about all that, but necessarily beginning with the Attorney General of the United States of America. Her name is Pam Bondi. And before we get to the events of this past week, stunning though they are, we're going to go back and do something that we haven't done in a long time, and that is give you some sense of who Pam Bondi is, because she was much on display this week in a way that I will offer to you is different from any of the 9 attorneys general for whom I worked over a period of 30 years, and should draw appropriately not just the criticism, but the condemnation of any American, regardless of your political persuasion, your partisan views, for her behavior and her conduct. But we'll do all of that when Amicus, a Law Review, continues right after this. This is Amicus, a Law Review. My name is Jim Santel. I am joined in the studios here of Racine Radio Park, my outstanding producer, Greg, who, as always, makes certain that we are on the air. He addressed those issues that prompted a bit of a late start, but we're not going to compromise on any content. Greg and I, instead, are going to be taking your phone calls, your insights, your perspectives, your questions. That phone number is 855-752-4842, 855-752-4842. You can also be in touch with the two of us by dropping your comments, your questions into the Civic Media chat box. Let's get right to it. Let's talk about Pam Bondi. Promising you a little bit of background, which we have not done in a couple of years. Important to go back and figure out who this representative of ours is, who now occupies this highest position in our nation with respect to federal law enforcement. Let me tell you a little bit about Pam Bondi. Pamela Jo Bondi, born on November 17th of 1965. She is now serving as the 87th United States Attorney General. I'm going to talk about 9 other attorneys general in just a few moments. And she served previously as the 37th Attorney General of the state of Florida. Lots and lots of information about her because she has been in the public domain. She was the lead attorney in an unsuccessful lawsuit to overturn the Patient Protection and Affordable Care Act. You know that as Obamacare. In a case called Florida versus United States Department of Health and Human Services. In that lawsuit that she spearheaded, Florida and some 26 other states argued that the individual mandate provision, remember that, of the ACA violates the United States Constitution. Unsuccessful in that litigation. In 2018, Bondi joined with 19 other states in an effort to overturn the ACA a second time, this time on its ban on health insurance companies charging people with pre-existing conditions. Remember that issue? Higher premiums as a result of that. Once again, Pam Bondi and those other attorneys general, while she was serving as the Attorney General in the state of Florida, unsuccessful in doing that. She defended something called Amendment 2. It's a 2008 amendment to the Florida Constitution, not the federal Constitution, the Florida Constitution that banned same-sex marriage against legal challenges on behalf of the state. Once again, unsuccessful in that. And interestingly, lots of other things in her official capacity, actually her private capacity, that also gathered a lot of attention, a lot of focus. In August of 2018, while she was serving as the Florida Attorney General, she co-hosted a show called The Five on Fox News and got a lot of criticism for that. Again, a public official serving as a co-host on what is undeniably a partisan news operation. And she told the Tampa Bay News at the time that no decision made by a commission that was reviewing this could be binding on her. She said the commission's general counsel did not make a determination about whether or not her appearance on that as a host violated the Florida Code of Ethics. The Tampa Bay newspaper described it as unprecedented for a sitting elected official to host a TV show. You may recall especially this bit of information. Remember as well that when she was running for the position of Attorney General, she received a number of fraud complaints regarding a thing called Trump University. And a spokesman for the Attorney General at that time announced that her offices were considering joining a lawsuit initiated by Eric Schneiderman, who at that time was the Attorney General of New York, regarding potential tax fraud charges against this particular entity, Trump University. 4 days later, and in the wake of that information, a political action committee established by Bondi to support her reelection received a $25,000 donation from Donald Trump and his foundation. Bondi subsequently declined to join the lawsuit against Trump University. Both Bondi and Trump, who is now our president, have defended any allegations that the donation was improper. All of that a part of our history. It is also a part of our recent history that Pam Bondi, in November of 2019, was hired by the first Trump administration to help the president, help the White House during the first impeachment proceedings. Her position was described the following month as being the role of attacking the process of the impeachment inquiry. Ultimately, as you know, President Trump not removed from that position. And finally, just by way of official information out there about her in the past, in November of 2020, again on another appearance on Fox News, the host challenged Bondi to provide evidence for her repeated claims of fraud in the 2020 election. And she said, "We know that ballots have been dumped." She later claimed that Donald Trump had won Pennsylvania despite votes indicating that indeed he had won not only the national election, but also there in Pennsylvania. A lot of things that have been a part of Pam Bondi's official out there public record since she has been the Attorney General of the state of Florida and since she has been the Attorney General of the United States of America. One other thing related to background, which is relevant to what I'm going to talk about in this hour and next hour as well. And that is that Pam Bondi is a graduate of the Stetson College of Law, Stetson. It is located in Gulfport, Florida. I'm going to give you the address and the name of the dean later on in our broadcast. Among some 100 schools in the United States of America, law schools ranked by U.S. News and World Report, you know they do that for all kinds of upper-level institutions. There are quite literally hundreds of law schools throughout the United States of America. The U.S. News and World Report agency, News Source, ranks all of them. And the Stetson Law School ranks 99th out of 100. That is not to say anything about the quality of the education. That is a law school that is indeed accredited by the American Bar Association, but it is significant that in its promotion as a school in the United States of America that teaches people law, that 36 years ago granted a law degree to our present Attorney General presently, and at that time as well, described itself as a leader not only in ethics but also in advocacy. On its present website, the Stetson Law School touts the fact that it takes a holistic approach to advocacy skills, oral advocacy skills, education that incorporates emerging trends to ensure that we are teaching with methods that remain relevant in an ever-emerging legal landscape. A huge amount of information about teaching legal communication effectively, being an effective advocate, doing that with ethics, and the present director of an institute on legal advocacy and involvement there at the Stetson College of Law said this: through rigorous and critical exploration of the discipline, she's talking about advocacy in the public domain, in the public venue, we play an essential role in leading the ongoing development of our discipline, both at the academic as well as the practical level. She went on to say, through this work, we set a high bar for practice. We ensure access to justice, and we protect the very systems that sustain our democracy. You know why I'm talking about that. You know why I'm talking about Stetson University. We'll get back to that at the end of our exposition here on Amicus of what our Attorney General, a graduate of Stetson University, did this past week. I would offer to you, in violation of all those fundamental things that the Stetson College of Law advocates for as a part of its education for its graduates, including our Attorney General, Pam Bondi. Let's get to what she did just this past week, once again appearing in front of the House Judiciary Committee. And this is a part of the House Judiciary Committee's plan and policy and requirement under the Constitution to engage in what we call oversight. This is exactly one of the key roles of the United States Congress, to ask questions, remember that as well, ask questions of witnesses, of people appearing in front of them about the operation of government. Why? Because it is the legislature that provides the guardrails in many ways for what the government does in other branches, yes, including the judicial branch, including especially the executive branch. Its oversight function envisioned by James Madison and George Mason as a part of our Constitution 238 years ago. And so when they call Pam Bondi in this past week, planned obviously, undeniably, the focus was going to be in part upon the Jeffrey Epstein files and the failures of this administration, the failures of this Department of Justice to comply with the law that the president signed, passed by the Congress to ensure the timely and complete and unredacted, in many ways, versions of the records, unredacted with respect to the perpetrators of the sexual abuse and human trafficking and sex trafficking for which plainly Epstein and others have been well known, but also ensuring the protection of victims, survivors of all of this. That was one of the major focuses. We'll get to some of that in just a moment or so. The other major focus of her appearance, this oversight appearance before the House Judiciary Committee, had to do with the politicization of the Department of Justice. This notion that because of the president's directives to the Department of Justice, because of the ways in which all the walls have now been broken down between the White House and this Department of Justice, the president basically serving as an additional attorney general, maybe even a super attorney general, in directing who will be prosecuted, how that will happen, who will be the targets of investigations, all the things that we have seen that have given rise to what we've described here on this broadcast as the constitutional crisis and the authoritarian government we have been in since 2025. Let us begin by talking then and providing some background for much of what happened over a period of 5 hours this past Wednesday. It was one of the most raucous, uncontrolled, and unprofessional presentations by any representative of an executive branch in front of the legislative branch in recent memory. Representative Jamie Raskin. Jamie Raskin, you know him well. He is a representative from the state of Maryland. He is now the ranking member on that committee. Began his opening statement. He's the top Democrat. And unfortunately, we need to talk about partisan politics in this. He's the top Democrat on the panel. Jim Jordan is the chair of the panel. He is plainly the top Republican there. He delivered a salvo of what can only be described as disgust in his opening statement about what he sees as a decimation of the United States Department of Justice. He started by criticizing Pam Bondi's handling of the release of the investigative files involving Jeffrey Epstein and Ghislaine Maxwell as well. Here's what he said. He said, "You're siding with the perpetrators and you're ignoring the victims." He said, "That will be your legacy." And indeed, that's the reason why we begin in reporting on this and talking about the legacy of this Attorney General. He said, "That will be your legacy unless you act quickly to change course. You're running a massive Epstein cover-up right out of the Department of Justice." That's how this committee hearing began this past week. Initially, of course, the Attorney General appeared somewhat unmoved, but she had a harder time evading some of the visuals in that hearing room embodied by, they were there. They were the Epstein survivors who sat solemnly behind her in that gallery. And during the course of this declining to apologize to them, only briefly casting her eyes in that direction. And along the way, more discourse between the representatives on that committee and Pam Bondi. We'll get to that right after this break here on Amicus, a Law Review. My name is Jim Santel, and this is Amicus, a Law Review. We are spending this hour and much of next hour as well talking about this calamitous testimonial appearance by our Attorney General in front of the House Judiciary Committee. Already told you a little bit about how Jamie Raskin, the ranking member, began that hearing. We're going to go right into the first of a number of excerpts from this calamitous 5-hour hearing. What you're about to hear is an exchange among the Attorney General, Pam Bondi, Jerry Nadler, who is a representative from New York, and that same Jamie Raskin from Maryland. Listen to the tenor and the content of this exchange.
So I really have just one question for you. How many of Epstein's co-conspirators have you indicted? How many perpetrators are you even investigating?
That was Jerry Nadler.
You showed it. I find it.
How many have you indicted?
Excuse me. I'm going to answer the question.
Answer my question.
No, I'm going to answer the question the way I want to answer the question.
No,
Your
you're going to
theatrics
answer the
are
question the
ridiculous.
way I asked it.
Chairman Jordan, I'm not going to get in the gutter with these people, but I'm going to answer the question.
How many have you indicted?
Again, the time belongs to me.
Reclaiming my time.
The time belongs.
I think it's very interesting.
Reclaiming my time.
I think it's very interesting.
And you can
that
reclaim
he
your
talks
time,
about they
reclaiming my time,
indicted.
Mr.
The
Chairman.
president said they indicted him twice.
Mr. Chairman, please
They
stop the
sure
clock
did.
and
he
restore his time.
Okay, here we go with these
Committee will get in order.
theatrics.
The time belongs to the gentleman from New York. We will give you a few more seconds. We will do that. But when you ask the question, the witness gets to answer. You may not like the answer, but she gets to answer.
The question was, how many of Epstein's...
They don't like the answer, Chairman,
my time.
because it's honest.
Reclaiming
So he asked a 4-minute question.
Restore 45
and
seconds,
I am
Mr.
going
Nadler, please,
to
Mr. Chairman.
Answer.
You can let her filibuster all day long, but not on our watch.
Reclaiming-
Not on our time. No way. And I told you about that, Attorney General, before you started.
You don't tell me
Yeah, I
anything,
did tell you because we saw what you did in the Senate.
Lawyer, not even a lawyer.
And in the wake of that exchange, you heard again from Jerry Nadler, from Jamie Raskin. You also heard briefly from Jim Jordan, and of course the Attorney General. It was in the wake of that exchange that she referred to Jamie Raskin, who did also graduate from a law school in America. The name of that school is Harvard. She called him a washed-up loser attorney, suggesting he may not be an attorney at all, which, of course, is completely wrong. Why do we begin with that particular excerpt? Because it gives you a sense of the demeanor and the lack of professionalism by this Attorney General in a situation where none of this had to happen. I note it is significant that even in connection with the question asked by Jerry Nadler, how many people have you prosecuted? Well, we know that there have been at least 2. We know that there was the prosecution of Ghislaine Maxwell. She is in prison right now for 20 years. And we know that there was the beginning of a prosecution before he committed suicide in custody of Epstein himself. The other significant answer that she could have given, other things that she could have done rather than engaging in the attacking language, the bad demeanor that is unbecoming of any government official, including the highest federal law enforcement officer in the land, is that given the fact that most of these events happened long before the indictment of Jeffrey Epstein, the most recent one of those happened in 2019. He was previously charged in 2008. There were indications that all this horrific behavior began as long ago as the mid-1990s and 1995. There were all sorts of events between 1995 and 2019 that were, in fact, the subjects of prosecution. She could have answered that factually and talked about the truth, which she made reference to, and then what could have indicated that, you know what, as much as we support the victims who are here in this chamber, who are here and deserve our respect and our concern, the fact of the matter is that the statute of limitations has now run. That's the kind of thing I would expect from a lawyer who is schooled in the law, who is holding this high position, who could have responded in a way that is factually responsive and meaningful to a good question that many Americans are asking about now. The fact of the matter is that all of these events happening certainly long before 2019, you do some math there, you realize that bringing a prosecution today, unless they're events after 2019 and 2020, that would revive, if you will, the statute of limitations, that would have provided an appropriate answer by my Attorney General. She chose not to do that, and in so doing, lacking the professionalism that we would expect from anyone in that position, the name calling, the lack of basic civility, the respect that you owe in both directions, congressman to witness, all of that lacking in this presentation. Beyond that, a huge amount of lack of competence here. Prepared to answer questions about things that the members of the committee were interested in asking about, and we're going to hear from more of them in our second hour. Instead, focusing immediately on the attacks. I will tell you that this kind of presentation also underscores for me, just like the Deputy Attorney General in his examination of Ghislaine Maxwell. Remember that when he went down there and met with her and deposed her in an embarrassingly bad deposition. Here we have another reflection of one of our top lawyers in America disclosing, revealing how bad they are as lawyers. This is not the kind of thing that any competent lawyer would do. Instead, you'd be prepared. All those volumes there would have answers to questions that are, in fact, answerable. And instead, as we'll get to in our second hour, they're referred to as burn books. What all of these are, they are preparation for attacks by this Attorney General on the people who are appearing before her. All of that about the lack of competence that she also brings to that, the deficits in these areas of professionalism and preparedness, which we would expect of any Attorney General. Beyond that, as I've indicated earlier, a lack of humanity, a lack of humor, a lack of personality, and some of those core legal skills that we would expect of lawyers and of law enforcement people in our nation. When we come back,
welcome to Amicus, a law review with Jim Santel, Civic Media's weekly review and discussion of some of the most significant news stories in the areas of law, government, courts, and the aspiration for justice. And now, here's your host, Jim Santel.
This is Amicus, a law review. My name is Jim Santel. This is the second hour of our weekend broadcast on all things rule of law related. We are devoting virtually all of our time this weekend in exploring with you this calamitous, embarrassing, unprofessional presentation by our Attorney General in front of the House Judiciary Committee just this past week. And we're providing you with some specific examples out of 5 hours of testimony. I hasten to add, as my wonderful producer Greg also encourages me to do, that none of this is edited. This is taken from C-SPAN. It is pure audio, and we are excerpting, admittedly, some portions, but not editing it. You're hearing exactly what the exchanges were between our Attorney General and various members of the committee. We talked already about the exchange between Jerry Nadler and Jamie Raskin and the chairman of the committee, Jim Jordan, and also Pam Bondi, that showed the lack of professionalism that any other Attorney General of years past would have shown, absent this one. Let's talk now about more exchanges between members of the committee and the Attorney General. Each one of them has a lesson to pull out about the deficits presented by our Attorney General this past week. You're going to hear next from an exchange between Pam Bondi, the Attorney General, and a Colorado representative named Joe Neguse. He's asking about the employment and hiring practices of the Department of Justice.
The man in that video, the one who was in the police-worn body cam footage, the one allegedly yelling, "Kill him," at police officers on January 6th, his name is Jared Wise.
He does work for us.
He works for you at the Department
Yes,
of Justice.
He does.
This is an individual whom a federal grand jury indicted for 2 felonies and 4 misdemeanors related to his participation in the attack on January 6th. One of those charges was forcibly assaulting, resisting, opposing, impeding, intimidating, and interfering with police with the intent to commit another felony. This is who you choose as the Chief Law Enforcement Officer of the United States of America to hire at the Department of Justice. Someone on video yelling, "Kill him," at police officers, right?
I believe he was pardoned by President Trump.
Oh, he was pardoned. You're right. You're right. Pardoned by President Trump for his offense. Pardoned for yelling, "Kill him," at police officers. And yet you expect hardworking police officers across the country to believe that you take law enforcement seriously. You could imagine the reaction of so many folks across the country hearing the Chief Law Enforcement Officer of the United States refuse to even condemn what that individual whom you've now hired did.
And that's Joe Neguse. He makes this all-important point there, those final words. Aside from the outrage of someone like this, who, again, pardoned by the president for his violent attack upon our nation on January 6th, and now back in the employment, apparently something that is a matter of some pride, perhaps, by this Attorney General. Joe Neguse actually invites the Attorney General to do exactly what she should have done. As a professional, as the Chief Federal Law Enforcement Officer, it's also a basic trial tactic. I don't mean that in a bad sense at all. It establishes credibility when you acknowledge you are wrong. What Joe Neguse was saying was this was a mistake, and every American knows about it. And every American understands that this person should not have been hired. Here, Madam Attorney General, once again, here's what you should have said rather than what you did, which is that we made a mistake. And when you do that kind of thing, as I teach law students and teach undergraduates and high school students who are engaged in trial practice exercises, when you acknowledge you have made an error, it pretty much shuts down the further examination. The outrage is still there, but you embrace the error that you have made. You embrace the problem, and you make yourself more credible. This Attorney General doesn't understand that, even after presumably 3 years of law school at Stetson College of Law. After all these years in the public domain, that's what the answer should have been, and it wasn't, once again. A lack of competence in preparing for these kinds of things and acknowledging once again that you can indeed admit an error. And it actually enhances your credibility, because when it comes to those things that you do want to fight about, you've got a better footing. Now, I recognize fully that that is not this administration. Plainly, this president does not admit any errors, and many people have commented about the fact that she was playing to a body, an audience of one. I would offer that she was playing, yes, to the president, but also playing to an awful lot of other people. And that's the reason why public domain presentations like this are so damaging to the nation, because what she is saying is that the government, number one, is perfect. It is not, and I can say that, loving my country, loving the government that I worked for 30 years, but also acknowledging that we have got work to do. Nothing wrong about that, nothing inconsistent about that. But it also sends the message to Americans that this kind of behavior where you refuse to acknowledge that there have been errors, that is acceptable, and that this behavior by this Attorney General denying any responsibility is something that all Americans can and should do. It is sanctioning the very thing that should be getting the condemnation of all Americans listening to her. That's the lesson from that brief excerpt between Joe Neguse from Colorado and Pam Bondi, repeated many times over the period of 5 hours. It's also, of course, the lesson between that initial presentation that we replayed between Nadler and Raskin and Jordan and Pam Bondi. We're going to go to another one and pull out yet another lesson of what should have happened, but what didn't happen from our principal chief federal law enforcement officer in the nation. We're going to play now an excerpt from an exchange between Pam Bondi and Ted Lieu. He is a congressman from California, and he also has some questions. Listen to this exchange between Ted Lieu, Congressman Ted Lieu, and Attorney General Pam Bondi.
Like former Prince Andrew, Donald Trump attended various parties with Jeffrey Epstein. I want to know, were there any underage girls at that party or at any party that Trump attended with Jeffrey Epstein?
This is so ridiculous, and that they are trying to deflect from all the great things Donald Trump has done. There is no evidence that Donald Trump has committed a crime. Everyone knows that. This has been the most transparent presidency. He's the one that asked that those files
I'm reclaiming my time.
be
I got your
released.
answer. You said there's no evidence.
Trump asked
Mr. Chairman, please stop the clock.
Stop
the clock.
The legislation.
Time.
This is
Time.
I'd like to
ridiculous.
reclaim my time.
Time belongs to the gentleman from California.
Okay. I'm going to put up another document from a witness who called the FBI's National Threat Operations Center, because I believe you just lied under oath. There is ample evidence in the Epstein file.
Don't you ever accuse me of a crime.
I believe you just lied under oath, and this is all on videotape.
Once again, what do we pull from that? This exchange from between Ted Lieu and Pam Bondi. Let's do a little bit of law practice, since Stetson College of Law promotes so much the advocacy here. Plainly, this is an example of a number of things, including a non-responsive answer. And that's the reason why but not only Ted Lieu, but others during the course of this extensive examination repeatedly said, I want to reclaim my time. What they're doing there is they're saying this witness who is called here to answer questions, not ask them, not engage in attacks, is using up time, and for that reason is answering in a way that necessitates reclaiming the limited amount of time that members of Congress have to examine the witness. It underscores as well this other fundamental part of what an attorney general, any lawyer, any practicing trial lawyer knows as well, and that is that questions are asked by the lawyers, and they are responded to, if at all, not here, they're responded to by the witness. The witness does not engage in attacks. The witness does not ask questions of her own. That's not how this works. That's not how the legal system works. And I would offer that even though this is not a court of law, she is under oath. She is called there by this committee of the United States Congress as a part of its oversight to answer questions. And in doing what she did, she once again either decided affirmatively not to regard, not to take into account any of the legal schooling that any of the lawyers in America get about the role of a witness and the obligation to provide answers, but also to do it in a way that is confrontational, that would, if you were in a court of law, incur the ire and the condemnation of a presiding judge. What you have here is someone who once again decided not to answer the fundamental questions, non-responsive. Reclaiming time necessarily is Ted Lieu as a part of this exchange between him and Pam Bondi. Of course, what you should do and what you can do. Undeniably, the congressman accuses her of engaging in perjury. She can calmly but resolutely pause, which we often teach as a part of our law school efforts as well and instruction as well, and simply say, Congressman, I reject that notion. I am testifying accurately. I am testifying honestly to the best of my ability, and you push back on that allegation without engaging in the kind of invective that only discredits your response that you do, in fact, make. That's the lesson coming out of that exchange with Ted Lieu. We're going to go now to another one, and this is going to be a bit of a diversion, if you will, but it underscores the other part of public presentations, which is some humanity, and yes, indeed, even in the midst of a calamity where we're talking about human trafficking, the notion that some self-effacing, some self-deprecating humor can also reduce the amount of tension. Listen now to a much more lighthearted exchange in the middle of this between Jared Moskowitz, he is a representative from Florida, and the Attorney General, in which he talks about something called a burn book.
Now, Madam Attorney General, I have like 25 seconds left. So because I'm curious, and I'd like to see you flip to the Jared Moskowitz section of the binder. I'm interested to see what staff provided on the oppo on me, and because we're in the Olympics, I'm going to give it a grade. I just want to see how good it is. So give me your best one.
So first of all, nothing is funny about mocking the Bible and holding up a Trump Bible. That's what you did. You made a joke, and I find offense to that. That's all I have to say.
I want it from the burn book.
Shame.
I want it from the burn book, which is the best one. What you got?
There again, we have got a master class in understanding public presence. This is not taught so much at law schools, but it is a part of public presentations. Our great presidents were self-effacing leaders who injected humor even sometimes here in the midst of great tragedy. Here is what the Attorney General could and should have done. Why not simply acknowledge what you're doing? We all saw it. You've got these binders in which you have got information about all these members of Congress. Not information responsive, once again, not information prepared by your staff and by you to provide the information that an oversight proceeding should be asking for, but rather attacks on them. Here's what she should have done, is simply read out loud exactly what it is she has in the burn book with respect to Jared Moskowitz, how effective that would have been and how meaningful it would have been in her presentation. This is Amicus, a law review. My name is Jim Santel. We are spending a lot of time this weekend on our broadcast necessarily talking about this presentation made by our Attorney General and examining why it is that America is responding so very badly to her appropriately and the things that she could and should have done as our chief federal law enforcement officer to engage with, admittedly, members of an opposition party, answering questions, acknowledging when there are errors, perhaps from time to time showing a little bit of personality and humor along the way when she's got that opportunity, and also providing a sense of compassion. We know that along the way, one of the most uncomfortable moments in the course of this 5-hour period was when Representative Pramila Jayapal, she is a Democrat again from Washington. She made an emotional appeal for the Attorney General to tell women that she was sorry for this sluggish release of the Epstein documents, inadvertently including the disclosure of victims' names that were supposed to have been redacted. And of course, along the way, also eventually inviting the Attorney General to acknowledge that in the course of this exposition, they're members of this victim survivor group right there, called upon to stand up, to identify themselves. You have seen the photographs, you've seen the video of this, the Attorney General not even acknowledging them. Again, another fundamental portion, another fundamental instruction of any good trial attorney is eye contacting. Letting people know that even if you disagree with them, whether it is members on the panel, but especially people who are there. These are the very victims that you support, the victims, survivors you purport to represent and to care for. You turn around and you look at them. And although it was unlikely, in that moment, I was thinking once again that this is an outstanding opportunity for my Attorney General to say, every member come up here. I want to hear your names. I want my staff to take your names. And yes, indeed, once again, we have failed in not talking with you. We are going to do that right now. Let's get your names. Let's get your phone numbers. Let's be in touch with you, not in the public domain, but ensure that exactly what the Department of Justice and U.S. Attorney's offices should be doing is done here, which is engage with them after the chances for more prosecution have been put aside, but showing exactly the kind of humanity and compassion that, again, every other U.S. Attorney General for whom I worked has shown during the course of his or her tenure. Every other person appearing in that situation would have done. That humanity and compassion completely missing. And then we have this. Then we have an exchange between yet another congressman, and it also underscores one of the lessons about how this should have gone, how the Attorney General failed in making anywhere near a good and effective presentation. This is an exchange between Thomas Massie. You probably heard a lot about this as well. He is a representative of Kentucky, and listen to the exchange between him and the Attorney General about the disclosure law.
So I'm going to put the language of the bill up on the screen.
Chairman, may I give my answer
question
on that?
Here's
It's a political
the question.
joke, and I need to give my answer on that.
We'll let the Attorney General respond, and then the gentleman can move to his next question.
It's my time.
Within 40 minutes, you asked me a question.
You can give
Within
me-
40 minutes, Wexner's name was added back.
Within 40 minutes of me catching you red-handed.
There was one redaction out
Where
of
he's
over
listed as a
4,700,
co-conspirator.
and we invited you in.
Show the video.
This guy has Trump derangement syndrome. He needs to get, you're a failed politician.
Gentlemen,
You need to
I
get
want
on
you to
these
watch the video.
matters.
Mr. Chairman, please restore his time and remind the witness of the
himself,
rules here.
there is no credible information. None. If there were, I would bring the case yesterday that he trafficked to other individuals.
Is that your position as well?
My position is any victim who comes forward, of course, we would love to hear from them. 1-800-CALL-FBI. Did you ask Merrick Garland that the last 4 years? Did you talk about Epstein?
I'm reclaiming my time. I'm glad you're asking about Merrick Garland.
You don't get to reclaim
because
time
this
when
is
you don't-
bigger than
when you can't-
Watergate.
when I don't answer a question the
this
way you
goes
want.
over 4 administrations. You don't have to go back to Biden. Let's go back to Obama. Let's go back to George Bush. This cover-up spans decades, and you are responsible for this portion of it.
And you are responsible for this portion of it. There is so much in that minute and a half exchange between Congressman Massie of Kentucky and the Attorney General to unpack. Let's try to do some of that. His last point is the reason why we're pulling it and presenting it to you again. This is not edited. This comes right off of the C-SPAN recordings of this. What does he say? And what should be and could be the answer of this Attorney General? I made reference before to the fact the statute of limitations has run. Why? Because Jeffrey Epstein's horrific behavior with respect to girls and women began in the 1990s. 1995 was the time that the first, apparently a 14-year-old girl came forward, had to get the attention of law enforcement, goes into the early aughts. June of 2008, he is first prosecuted. He gets 18 months in prison, spends 13 months in jail, and ultimately re-indicted by the federal system in 2019, the case pending at the time of his suicide. What is the point of that? What is Congressman Massie saying? There is responsibility over the period of decades. That's the answer that you give, Madam Attorney General. Instead, what you do is you attack the congressman himself, who's giving you the very answer to the question that he's asking. You call him a failed politician. The name calling continues once again. You also talk about this redaction. Again, simply acknowledge that there was a redaction that had to be remedied, and that this congressman was a part of that process, restore the integrity of the record, sort of cryptic in that particular recording. All of those kinds of things should have been the focus of measured and decent responses by this attorney general. They were not, in fact. And that's the reason why we play all of this. As we talk more, we're going to chat more about the exact reasons for America to be outraged by this conduct as Amicus, a law review, continues. My name is Jim Santel. This is Amicus, a law review. We are in this segment beginning to conclude our exposition of this horrific rule of law event from this past week, which was the appearance of our Attorney General in front of the House Judiciary Committee. Now, admittedly, this is a partisan proceeding, and everybody knows that they're on cameras, and everybody knows that the things that they're going to be saying are going to be bandied about in America, just as we have done on this broadcast. And so the focus on our Attorney General is once again the professionalism not shown here, the lack of basic competence in not preparing substantive answers, knowing that there are good substantive answers to some of the questions. Her decision instead simply to interrupt and charge the members of the committee with partisan animus here. Her focus instead upon attacks, name-calling, which of course is exactly what her boss, the president, does. Lack of humanity and compassion in turning around and looking at those survivor victims in the very chambers in which she was appearing. Some self-effacing humor. Acknowledge that you've got a burn book there, and you will, I'm sure, get smiles, maybe even laughter. You heard a little bit of that during the course of the exchange between her and Congressman Jared Moskowitz. A lack of engagement, lack of personality. In any trial setting, and this is not a trial, this is not a courtroom, but you're trying to persuade the American public. You are arguably trying to persuade members of this committee, providing them with information. You're trying to persuade them, although it's a difficult task, that the Department of Justice is acting appropriately, and so do it in a way that engages them, that acknowledges the legitimacy of their questions. She did none of that. Core legal skills missing. How, as a witness, effective? You listen to the question, you pause, which is something that I advocate for all of the students that I teach. You think about your response. You are respectful in doing so. You admit errors, as I've said repeatedly. We know today that this administration can do it. There's reporting as late as this weekend that the leadership of ICE is indicating that indeed there were a couple of officers that lied in connection with the shooting of a fellow named Julio Cesar Sosa Celis in Minneapolis. They shot him in a leg. There is an investigation going on there. Why? Because someone acknowledged that something bad happened. That is appropriate for government to do on its core level. It also enhances your credibility. Everything that this attorney general should have known as a lawyer, as a trial lawyer, none of it on display this past week in a way in which she could have presented facts and information much more competently. And in the end, as I started out, bad advocacy. It comes, interestingly, at the same time that her law school, as I said at the outset, touts its advocacy skills. And certainly 36 years ago, that was also a part of what the Stetson College of Law was all about. And so the question comes, what about history? I've worked for 9 different attorneys general. And most of them, 6 of them are Republicans, 3 of them are Democrats. I worked for Ed Meese and Richard Thornburg and, yes, William Barr in his first incarnation. Those are my early years as an assistant U.S. attorney. I worked directly at Maine Justice for Janet Reno for 2 years, also with Eric Holder. I worked with John Ashcroft when I was the interim U.S. attorney, court appointed and also attorney general appointed. I worked with Alberto Gonzalez also when I was in Iraq for a couple of years. I was there with him at the embassy, talking with him, engaging with him. I worked with Michael Mukasey, also another Republican, during the time that I was in Iraq and coming back, I worked plainly with Eric Holder, who was my boss when I was the Senate-confirmed presidential appointee, and I worked for Loretta Lynch, who was my colleague from New York, who became the U.S. attorney, 9 different attorneys general, Republicans mostly, some Democrats. At no time during any of those exposures with them, and I had direct contact with many of them in the latter portion of my time with the Department of Justice, did I see any of the lack of professionalism and compassion and basic understanding about how this works that this Attorney General has shown. This is, if not unique, it is certainly atypical, and Americans should know that. I also want to comment about this other aspect related to practice of law. I mentioned now a number of times that I work with high school students and college students and some law students as well in their mock trial areas. I talk about all these kinds of things, including listening and pausing and thinking thoughtfully about the answers to the questions that are being posed to witnesses. We talk about the ways in which you follow up with witnesses who are not responding. In this case, in Congress, it's reclaiming your time. In a courtroom, it's asking the judge to compel the witness to answer the question that you have asked. All of that to indicate that Pam Bondi knows better, or she should know better, and as the chief federal law enforcement officer, she should be embarrassed by this particular performance. Now, what do we do? What do we do with all this? We can complain about it. We can be outraged, as I plainly am, by the performance of my attorney general, atypical of anything that I have seen from Republican and Democratic attorneys general in all of my time. What do we do? Well, once again, it's going to go back to what I've advocated in the past, and I'm going to give you some addresses and some phone numbers, because I believe that if, in fact, the American population lets this attorney general and her staff know that we do not only appreciate her performance, we condemn her performance as being a waste of time, no serious information being conveyed. When there were answers to those questions, we could have benefited from some of the information provided. Let's go back. Let's go back, number one, to the Stetson College of Law. The dean of that college, not the dean when she was there, is named D. Benjamin Barrows, B-A-R-R-O-S. Write him a letter and ask if the Stetson College of Law, that promotes itself as being a high-level advocacy teaching law school, that promotes itself a holistic approach to advocacy skills, is proud of this graduate of the Stetson College of Law. Here's the address: Dean D. Benjamin Barrows, the Stetson College of Law, 1401 61st Street South in Gulfport, Florida. 1401 61st Street South in Gulfport, Florida. The zip is 33707. And the phone number, if you care to call and leave a concern about the level of advocacy that is now being shown by their graduate, is 727-562-7800. They are an institution that should, in fact, know about the lack of advocacy, the lack of skill, the lack of professionalism and humanity, and yes, indeed, also the lack of basic humor and personality and genuineness that adds credibility to any witness like this. This is not a graduate of whom the Stetson College of Law should be proud. And there is another address, as we have done before, and we'll talk about that one as well. And it is, of course, the address for the Attorney General of the United States of America. She is Pamela Bondi. She is the Attorney General of the United States of America. Her address is 950 Pennsylvania Avenue, N.W. Northwest. 950 Pennsylvania Avenue Northwest. That's Washington, D.C. You know that. The zip code is 20530. And the phone number is 202-514-2000. 202-514-2000. It is appropriate for Americans to send a letter to your Attorney General. She is there, as she said during one of the exchanges, she is there to represent the American population. And she's also there to respond to criticisms, concerns. She's there also to take all kinds of comments from you. Why? Because she serves you. She does not serve the president, nor do U.S. attorneys serve the president. They serve you. Even though she has said that publicly, even though that's what the president has said, that is not her role. And so that perhaps is one of the things you want to remind her about when you write that letter to her at Main Justice, the RFK, Main Justice Building on 9th and Constitution Avenue, 950 Pennsylvania Avenue Northwest, Washington, D.C., 20530. You may think it may not accomplish anything. It will do at least these two things. You may be assured, I worked there directly and was visiting at Main Justice many, many times during the course of my career. For 2 years, I worked in that building. I know that letters to an attorney general are received and staff looks at them. And I know, too, that on admittedly rare occasions, they do prompt responses by the elected and appointed representatives in Washington, D.C., including someone like the attorney general who's appointed to serve and provide support to you. Do that. It will also do one other thing, and that is prompt you to codify your views. That's the role of this broadcast, to give you some information, to give you some sense of perspective, but also to permit you to winnow and sift through all of this and make determinations about how you feel. You don't have to write a letter that includes all the things we've talked about over the period of the last 2 hours, but identify 2 or 3 of them: the lack of professionalism, the lack of compassion, the focus on the failure of the Department of Justice to do what it was obliged to do under the legislation, even absent legislation, to provide this information, the continuing failure of the Department of Justice plainly to provide support for the victims, survivors of the Jeffrey Epstein melee, of the catastrophe that has attacked this nation for decades now. Write about something that you care about and let Pam Bondi, the Attorney General of the United States of America, know how you feel. That is an important thing to do. That's representative democracy. And at a time when we are challenged both by a crisis in constitutional basic structures, we are in a constitutional crisis since almost for the past 11 months, since March of last year. We are plainly working under an authoritarian government. All of that requires that Americans be heard, that all of that continue to be a part of the advocacy that you do with respect to our government. We have got, as I said at the outset, an awful lot of other things that happened during the course of this past week in the area of the rule of law. Let me give you some samplings of some of those things. You have heard about them because in the wake of this catastrophic event on Capitol Hill, you should know that some of the safeguards and the guardrails continue to be in place. You know well that a federal grand jury in Washington, D.C. this past week refused to do what the Attorney General and the President wanted to do, and that is indict active duty members of the military and intelligence community and former members of the military who had gone on a public forum to tell members of the military that they have an obligation to refuse illegal orders. And as a result of that conduct, which is a part of their First Amendment rights, as you know, the administration responded badly to this, initiated proceedings inside the Pentagon with respect to one of those members of that group, and also this past week sought to indict 6 members of Congress, all of whom had served in the military or in the nation's national security agencies. It is remarkable that a group of ordinary citizens sitting on the grand jury, presented presumably with charges against these 6 individuals, said no. That's a guardrail of which everyone in America should be proud. Once again, regardless of your partisan view, that system works. It is the system established by our founding fathers that requires that before you can be charged in a federal system, it's not an attorney general, it's not a president, it's not a U.S. attorney, it's not an FBI agent, it's not an assistant U.S. attorney. It is members of the public brought together, convened together in a grand jury to determine whether there is probable cause to indict. And this past week, and a grand jury said no. When we come back, we'll talk a little bit more about other things from which we can take solace in the rule of law here on Amicus, a Law Review. This is Amicus, a Law Review. My name is Jim Santel. This is the final segment of our broadcast this weekend, talking about reasons to be positive in America, even in the wake of this calamitous presentation by our Attorney General this past week on Capitol Hill. We've got a grand jury that has refused to indict 6 members of Congress for stating what the law is. That's a representation of how our Constitution still works. On Tuesday, prosecutors were presenting a case attempting to persuade these grand jurors, they're members of the public, that these lawmakers had violated a statute. What does it do? It forbids interfering with the loyalty, morale, or discipline of the U.S. Armed Forces. And the grand jury said, no, we're not indicting. Go away, members of the prosecution team. That's significant. No First Amendment violation here in their speaking as they did. A grand jury refusing to indict. That is power. That's authority of the people. You've got inside the judiciary another judge. His name is Richard Leon. We've talked about him before. He's in the D.C. Federal court there. He wrote in a 29-page opinion the Defense Department's move to discipline Mark Kelly, who's a Democrat from Arizona, for participating in that video that warned about active duty service members not following illegal orders. The judge just this past week saying that Hegseth and the Pentagon generally cannot take any steps to reduce the senator's retirement rank or pay, or using the findings against Kelly in a criminal proceeding rather than trying to shrink the First Amendment liberties of retired service members. Secretary Hegseth and his fellow Democrats might reflect and be grateful for the wisdom and expertise that retired service members have brought to public discussions and debate on military matters. That's what Judge Richard Leon said in shutting down the other attempt by this administration to go after these members of Congress, including Mark Kelly. There are other things going on in America with respect to federal judges. We've got federal judge James Boasberg, again in the D.C. Trial court, who this past week finally ordered that those deported Venezuelans be returned to the United States. He orders that the United States bring back 137 Venezuelans and cited as precedent the well-documented return of Kilmar Abrego Garcia from El Salvador's high-security prison. The order, of course, coming after literally almost a year of the judges attempting to wrestle with what the government has done, deceptions and lies and misconstruing the facts in front of him. Of course, that will be appealed, but the judge saying to the government, return these people and give them the due process that they deserved, that they were not afforded almost a year ago. And we've got another judge, and this one is Georgia Alexakis, and she is in the federal district court in the Northern District of Illinois. She is in Chicago, and she is doing something in the wake of some of the calamity in that city. She is allowing the release of evidence, including body camera footage and some text messages from October. At that time, you may recall there was a shooting of Marimar Martinez, a 30-year-old teacher's assistant, by Border Patrol agents there in Chicago. The evidence then was gathered together in the thought that actually Martinez might be charged with a crime. In fact, that now defunct criminal case had been abandoned, but had been sealed by a protective order. The judge saying, you know what? In the wake of all of this activity, the American public, including the folks there in Chicago, need to hear about this. They need to see the video of this incident as soon as the materials can be redacted to obscure the identities of some other parties not involved. And that could happen. That could happen as soon as this coming week. Again, Georgia Alexakis from the Federal District Court for the Northern District of Illinois, entering an order that affirms the transparency of what our government should be all about and needs to be all about going forward. Many other things going on, and we're going to talk about them in our next installment of Amicus, a Law Review. We're going to talk about things going on inside the Department of Justice, yes, with respect to questions being asked of new incoming assistant U.S. attorneys, questions about loyalty to the president. We'll talk about yet another U.S. attorney as a revolving door in the Northern District of New York being hired and fired. We'll talk about that affidavit coming out of Fulton County, released this past week, that shows, in fact, that there was little to no probable cause that justified the seizure of those 700 boxes of voting materials. And we'll talk, yes, indeed, about the decision by this Department of Justice, by this Attorney General, to abandon any further case involving Steve Bannon. basically sending message to the Supreme Court to send the case, the criminal case for contempt of Congress, back to the lower courts. So what can happen? So the Department of Justice can move to dismiss that prosecution easily, the second, if not the third time that Steve Bannon has gotten the privilege of knowing this president and having an attorney general or Department of Justice who metes out justice in a way that covers and fails to ensure the enforcement of the law. Steve Bannon, once again, not being subject to the kinds of things that you and I are, the rule of law, again, not applicable to everyone in America. There is a lot going on. There's a lot to be concerned about. There is a lot to be proud of in this nation of ours because we can still speak about these things. We can still advocate about them. We have grand juries. We have federal district court judges. We've got letter writing. We've got people inside our institutions of government, including our major agencies. And we've got you who can continue to be heard on the streets of Wisconsin and in every other state and territory of this nation. All of us can be heard as a part of our process going forward. That's what America is all about. And that's why this continuing effort to ensure that the democracy that we have pursued for the last 238 years is preserved going forward. Always my pleasure, my honor, and my delight to be a part of your weekend. I encourage you to tune in next week for more of this right here on the Amicus, a Law Review, here on the broadcast stations of Civic Media. Have a good weekend, everybody.